All righty, so we are back. John Kuntz, who is your client?
Judge, it's Michelle Orozco Duque.
All right, do you need to
We're-
go into the breakout room with her?
Well, I just realized that we struck a plea bargain with Marcus, but I haven't gotten paperwork yet.
All right, and you say it's with Marcus?
Yes, Marcus was the one that negotiated it with
All right,
me. And so,
all right, Marcus is here and
okay.
he will get paperwork to you.
Thank you very much.
You're welcome. I'm going to open rooms. Nobody go to a breakout room unless I specifically call your name and assign you to one. So, Ms. Orozco, I'm going to send you to breakout room number 1. And John Kuntz, if you go to number 1. Everyone, just give me a moment, please. All right. And everyone, just one moment. We're waiting for a prosecutor. All right, the attorney on Carlos Vasquez. I don't see you here. Justin Fox. Marcus. John Kuntz needs the paperwork on Orozco.
Yes.
Judge, you call me?
Yes, Justin Fox. Who do you have?
I have Delano Daniels, Judge. It's a motion to withdraw his counsel. And
All
I'll
right.
just,
We're going to see if he's in the courtroom.
okay.
And Mr. Cox, you need to remove your cap.
And then, Judge, when you have a chance, if I could go with you and the state in a breakout room, if possible.
All right. Who is the prosecutor who will be handling Daniels?
I can, Judge.
All right. I'll see you in breakout room number 2. All right, Deputy Laura, is Mr. Daniels in the courtroom?
Yes, Your Honor.
All right, yeah. Mr. Daniels, can you approach, please? Mr. Daniels, my understanding is that the plea offer has been tendered to you. Is that correct?
Yes, ma'am.
All right, I need you to speak up.
Yes, ma'am.
All right, are you rejecting that offer?
Yes, ma'am.
All right, so do you want a jury trial or a bench trial?
Jury trial?
Okay. All right, we're going to go on the record in this case. Your attorney wants to withdraw.
Yes, ma'am.
Who is the prosecutor who can get on this case, please?
I can, Judge.
All right. All right, the court is calling 2019 CR 11380, State of Texas versus Stolodon Dario Daniels. If I can have parties announced for the record for the state,
Alexandra Williamson?
for the defense.
Justin Fox for the defense.
And are you Mr. Daniels? I need you to speak up. Nobody can hear you. Are you Mr. Daniels?
Yes, ma'am. I apologize.
No problem. Your attorney has filed a motion to withdraw because you're not abiding by the terms of the contract. Defense?
Yes, Judge. So we have a contract with Mr. Daniels, and he hasn't complied with the second portion of it, which is complying with the trial fee portion. So we'll be withdrawing as counsel. We've communicated that to Mr. Daniels.
All right, Mr. Daniels, if you want someone to represent you and you're paying for them, you have to pay the fee.
Yes, ma'am.
That's the way it works. So I'm going to grant the defense's motion to withdraw. Next, Mr. Daniels, there's been a motion because your bondsman wants off your bond.
Yes, ma'am. I have a statement on that, if I may.
Yes, you may say your statement.
I had talked to Albert Acevedo and Rangel, and they had covered my bond, as I have right here in my hand. And so I was trying to see about doing a satellite bond.
I have no say over that, but what I'm telling you is you're going to be taken into custody today because the bondsman has gotten off your bond, and that bondsman was Mark LaHood.
Yes, ma'am. But I guess I described it wrong, but what I'm saying is I've already reposted the bond, if that's okay.
Well, they will check to see if it's in the system. If it's not in the system, you're going to get taken into custody.
Yes, ma'am. Not a problem.
All right, Norma, can you give Mr. Daniels a reset date? And it's a jury trial date.
Yes, ma'am. Can I have the case number, Judge?
It is 2019 CR 11380.
1 second. Did you want me to have him brought back in 30 days, Judge, or
Yes.
we can do, I can do the May 6th, Judge.
All right, we'll see you back on May 6th. If you plan on hiring an attorney, that attorney needs to show up. You need to let that attorney know that you will be scheduled for jury trial and that the court will not accept any plea bargain agreements. Do you understand?
Yes, ma'am. And if I'm not able to have an attorney by then what should I do, or who should I contact?
If you cannot afford to hire an attorney, then one will be appointed for you if you qualify for a court-appointed attorney. Do you understand?
Ma'am, thank you so much.
All right, you're welcome. Mr. Fox, you're excused unless you have something else with us.
No, Judge, nothing, and then nothing with you tomorrow, so happy Easter.
All right, happy Easter to you too.
Take care, bye-bye.
Bye-bye.
What is wrong with this? Oh, no. Can you see me?
Mr. Simmons?
Good afternoon, Your Honor.
Yes.
I was here on Mrs. Tony Arcy. We had filed a motion and we were seeing about what day the court would want to hear that. But then I was informed today that she had a compliance hearing. So I told her to make sure that she's here. She is here. That motion was filed on Monday. If I could speak to or if it pleases the court, if I could speak to a prosecutor just to
Hello.
see if there's
All right,
anything.
is there a prosecutor available?
Judge, I'm here. I think I reviewed this one. I'll talk to Mr. Simmons if he wants.
All right, Mr. Simmons, I'm going to send you to breakout room number 2. A prosecutor will meet you there.
Thank you, Judge.
You're welcome. Eduardo Jimenez?
Yes, Judge. On my
What's
laptop,
happening with-
everything's under control. I believe you said that today was Damian Valdez's last day to make a plea bargain.
Yes.
So he has to decide. I made him aware of what the two options were, and
All right,
he
Mr.
wasn't
Valdez,
able to make it.
I'm sorry, what?
He was not making a decision at that point when I was talking to him.
All right, Mr. Valdez, go to breakout room number 3. Your attorney will meet you there.
Yes, Judge, thank you.
You're welcome. Who is the attorney for Cucco?
I am Judge Ronald Ortman.
All right.
Yes, sir.
And you are here for what?
Two different issues, one of which is we're asking for an increase in the budget for the investigator who has been appointed to the case. And so we did file a motion for that.
All right, and what else are you here for?
This is our third attempt at a bond reduction. He has been offered a place as a residential facility if he can be released, and has no means of paying a $50,000 bond.
So before we go on the record, what type of bond are you requesting?
I know that in the past he's asked for a PR bond. I've been asked by him and his parents for that, and I know that it's not possible under current conditions. So it would have to be a bond that's low enough for them to be able to either pay it in cash or alternatively through a surety. And it's set currently at 50. It started at 75.
All right, who's the prosecutor who's been who you've been conferring with or working on?
Marcus Sanders.
All right. So is there an agreement on the bond motion to reduce bond or no?
There is
Not
not.
that I'm aware of.
We previously agreed to 50 and
Okay. All right, we'll start with that. Let me find the motion.
What is that specific?
Ready, Brenna?
599.
Court is calling 2019 CR 12887, State of Texas versus Ross Cucco. Could I have the parties announced for the record for the state,
Marcus Sanders.
for the defense?
And Ronald Ortman for the defense.
And are you Mr. Cucco?
Yes, Your Honor.
Am I pronouncing your last name correctly?
You are, Your Honor, and I just feel a little awkward. I don't know if should I stand or should I stand and sit up real
No.
quickly or.
No, you can remain seated.
All right, Your Honor.
It
Yes, you
makes
did.
things easier for the deputies.
No, you did pronounce it correctly. You have, and that's a rarity.
All right, thank you. See, Brenna, I have learned that in some cases, it is true what I learned in elementary school, that when two vowels go walking, the first one does the talking. But in other cases, it doesn't work. I don't understand. All right, we're here on a motion to reduce bond. Are both parties ready to proceed? State?
Yes, Judge.
Defense?
Yes, we are.
All right. And we're proceeding by video because of the pandemic. Any objection from the state or the defense?
No objection.
No objection, subject to the caveat that his parents are in the courtroom, and I do intend to call his dad as a witness.
They will be allowed to be witnesses. Mr. Cucco, do you have any objections to this proceeding by video?
No, no, Your Honor.
All right, Mr. Cucco, are you able to mute and unmute yourself?
I am, Your Honor.
All right, so what I'm going to do is I'm going to mute you. If
Okay.
ever there's something that you need to say or you have a question about something, just raise your hand and let me know. I'm going to mute you because there's a lot of noise that's coming from your end, and it's hard for the court reporter to hear and for me to hear, okay?
Yes, Your Honor.
All right, Mr. Ortman, it is your motion.
It is, Judge, and we'll call Nicholas Cucco as our witness, first witness in this matter.
Deputy Laura, is there a Nicholas Cucco in the courtroom?
Yes, Your Honor, he is here.
Okay. All right, if he can come up, please.
Closer, sir.
Mr. Cucco, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. I'm going to need you to speak up so that the court reporter can hear, okay?
I do.
All right. Could you state your first name for the record, please?
First name is Nicholas.
And last name?
Last name is Cucco, spelled C-U-O-C-O. We pronounce it with the letter Q, Cucco.
All right. Thank you. All right. Defense?
Thank you, Judge. Mr. Cucco, your relationship to Ross Cucco?
I'm his father.
Okay, and are you aware that he is currently being held in custody at Bexar County Jail?
Yes, sir.
And are you aware that he could be released upon posting a $50,000 bond?
Yes, I am.
Okay, and can you afford to post a $50,000 bond for Ross Cucco?
No, sir. That's why he's been in there a year and a half.
Okay. Could you afford to post $5,000 in order to get a bail bondsman to post a surety bond for Ross Cucco?
$5,000 is what I have to pay 10% of that?
No, 5,000 would be 10% of the 50,000.
Oh, no, no, sir. I would not be able to afford that.
Are you and your wife currently living on your Social Security income?
Yes, we are.
Okay. And how much could you afford to post if you had to post cash for his release, for Ross's release? How much could you afford to post?
My wife and I talked about that today. We were thinking between $200 to $300 maximum.
And if Ross were to be released from custody, would you like for the court to dispense with the current GPS ankle monitoring requirement?
No, that's one of the stipulations that we were requesting or asking for.
That he be released from it, correct?
Correct.
Okay. And why is that? Why do you want him released from that requirement?
We have got an approval from a facility that has accepted Ross with a signed letter from the director into a recovery program. It's a minimum of 12 months, but they do not allow ankle bracelets in their program because they go out of the house and sometimes come back at hours that don't conform to the ankle monitoring process. They're in full control and guidance over their out of the residents in this house, but an ankle monitor is not allowed.
Okay. And can you offer your good faith assurances to the court that you will do everything you can to make sure that Ross Cucco appears for every subsequent hearing in this case?
Absolutely. And I do have, in addition to that, I have a confirmation from the director and the staff personnel that they will provide transportation and assistance for every appearance that's necessary.
I pass this witness, Judge.
State.
Mr. Cucco, how much do you and your wife receive in Social Security or any type of benefits?
A little less than $3,000 a month.
Okay. Do you own any property?
We have our house, but we don't own it outright. We have a.
I'm sorry, you cut out for me. Could you say that again?
Do own a home, but it's a mortgage. You know, it's mortgaged.
Okay. And do you have vehicles?
Yes, we have one vehicle that has a payment on it also.
Any other income, any money in a savings or checking account?
Well, our deposits go directly into a checking account.
Okay.
That's how we pay our bills, pay our utility bills and our light bills and car note, house note goes into a checking account. We do have a checking account.
No savings account?
I think we do have a small savings account, probably less than $100. It's just there for.
Does your son have any siblings?
He does.
Have you reached out to them to see if they are able to provide any money to help?
Well, one's a minor, and
I'm sorry, one is a what?
Unemployed minor.
Unemployed
Minor. One is has been unemployed for about the last year and a half because of the COVID, and the other's newly in the Navy and is on a very limited naval income, so he can't help.
And what about your son? Did he have income prior to being booked?
He had a real good job actually, and he was working out of town, and through some misunderstanding by him, he thought he was. I posted a $1,500 bond for him, and then he was supposed to pay $100 a week. He thought, and I thought, that was going to be able to be paid when he got out every 2 weeks, because he was working out of town and he got behind on the payments, and they revoked his bond. But now he doesn't.
Yes, sir. You're talking about for this case, right?
For this case, yeah, he was out and working, and they revoked the bond because he didn't make the $100 a week payments, and he couldn't drive 350 miles in once a week to make the payments. And there was some confusion as to the fact that he was told by somebody that he could make them monthly. It wasn't accurate. So he got behind on the payments, and they revoked the bond, and he's been in jail ever since, almost a year now. And he was in jail like 4 months before that, before he was able to come up with the $1,500 to post the bond originally. That pretty much eliminated our savings when I posted the bond the first time.
Your son has some criminal history, correct?
Yes, he does.
Not only in Bexar County, but in Harris County and New Braunfels and a few other cities and jurisdictions.
Yes, sir.
Gonzales County, Bandera County. Are you aware of the violent offenses that he has?
Never had a violent offense that I know of, except for this one that's I think is false testimony, but that we're not here to do that today. But all of his other ones were, I think, nonviolent, and they were all as a result of his admitted drug addiction of not narcotics, but what do you call it? Pharmaceutical drugs. He has a 12-inch titanium cage in his back, and he takes pain medication. And through the years, he's abused that. And when he couldn't get pain medication, he started using street medication. And then when you start using street medication, you can't keep a job, and it spirals downward. But he hurt his back at age 16, and has been in a lot of pain ever since. And after he got the medication, he was doing well until the medication wasn't working for him, and he started taking more than he's supposed to, and got addicted to the pharmaceutical. I don't know the name of it. It's the one that's very prevalent today in our society. The pain medication.
Mm-hmm.
And so, he's not a violent man of any kind. He's an addict.
Are you aware? Let me cut you off for 1 second. Are you aware of his most recent arrest prior to this one? It was an ABI family violence out of Guadalupe County.
I'm going to object to the question, Judge. He may not know what ABI is. That's a term of art.
Are you aware that he has an assault case involving a family member out of Guadalupe County that he's been convicted on?
Assault case on a family member. I don't know about that at all. No. Is this family member the same one that the case we're discussing now?
Well, no, the case that we're discussing now isn't a family case.
Okay.
A
family member. He doesn't have any family. I don't understand. Besides me and his mother and his daughter and his son in the Navy. I don't know where you're getting that information.
I have his criminal history, but it's okay. I'll pass the witness, Judge.
All right. Defense, any other questions?
Nothing for this witness, Judge.
All right. Thank you, Mr. Cucco. Call your next witness, please.
I'll call Ross Cucco.
Do I sit down or stay?
Okay. Mr. Cucco, could you unmute for me, please?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record, please.
Ross Gene Cucco.
All right, defense.
Mr. Cucco, do you have the financial means to post $50,000 bond in order to secure your release?
No, sir, I do not.
Okay. Do you have the financial means to post $5,000 with a bail bondsman in order to secure your release through a surety bond?
I don't, Ronald.
Okay. And then are you able to offer this court your assurances that you will faithfully show up on time for each and every subsequent hearing in this case?
10 minutes early to each appointment, without a question. This is as serious as a heart attack, and that's the mindset and the manner that I will take with me until I'm exonerated from these charges.
By signing, I agree to both this agreement
and one more question, Mr. Cucco. Can you give this court your solemn assurances that you won't be a risk or a danger to the community if you're released on bond?
Not only will I not be a danger to the community, but I know that I'm going to be a blessing to the community. I have the privilege and the opportunity of a new mindset, and I'm just carrying this attitude and this new song that's in my mouth with me everywhere I go.
I pass the witness, Judge.
I'm sorry, state.
Yes, sir. Cucco, we discussed a lot of this at the last hearing, but isn't it true that you're alleged to have assaulted a disabled person, and that's why this is an aggravated robbery, right?
Yes, Marcus. How are you doing, sir?
I'm good. Thank you.
Marcus, I'm just looking forward to having the truth be told and all the evidence being laid out so that the truth can set me free. And I appreciate you, Marcus. And I just thank you. And Ronald and Miss Boyd and God bless you guys. And I know that the truth will be exposed, And this will all come to an end shortly. So I'm looking forward to that, Marcus. I'm not trying to run from this. I'm not in any way, shape. I've been patiently waiting, and I just can't wait for that day.
You mentioned running. Isn't it true that you actually have a conviction for evading from the peace officers?
Marcus, I have an extensive rap sheet. That's
Mr. Cucco, I'm sorry, I'm gonna have to ask you to speak up. I'm sorry, I know that there's a lot of noise going on behind you. I'm gonna have to ask you to speak up.
I apologize, Ms. Boyd. To answer Marcus's question, yes. There's no question about my history, Marcus. But like I said, this is a bogus retaliation charge, and the truth will come out. And I'm looking forward to that. Matter of fact, it's been a long time coming, and I'm welcoming it. And to answer your question, Marcus, yes.
And your rap sheet, your history, it goes back to 1995, correct?
Yes, Marcus, it's extensive, and that's something I can't deny, and yes.
And most recently, it was an assault, family violence out of Guadalupe County.
The defendant in this case, that this charge here, is the same defendant.
Oh, yes, sir. Go ahead.
The Crystal Simpson, who is the alleged victim, is the same one who did that to me before. So, yes.
And you pled to that one, correct?
I was in jail on another charge, and I pled no contest so that I could be released.
I'll pass a witness, Judge.
Defense?
Nothing more for Mr. Cucco, Judge.
All right, Mr. Ortman, call your next witness.
That's all of our witnesses, Judge.
All right, then the court will hear argument. Defense?
Judge, he has been in jail for, let's say, around 450 days now, I believe. That's ballpark number. It's about a year and a half. His bail started out at when I was on the case at $75,000. It's been reduced by this court to $50,000. He does have a guaranteed entry into this residential rehabilitative program if he is released on bond and also not subject to the GPS. And then we're asking the court to do that. The bail has to be set within his means. He can't be held without bail, except in a capital case. And to set bond this high at $50,000 is essentially the same as holding him without bond. He can't make it. His family can't make it. Full stop. He's not going to be a risk to the community. He's been in jail for, like I said, about a year and a half. So the addiction issues are behind him now. So we're confident that he can go out, take part in this rehabilitative program and do so successfly, and also to show up for each and every hearing, subsequent hearing in this matter.
We were actually.
All right, stay.
No, excuse me.
Judge, I don't think the testimony was sufficient to show that the family did not have the means to raise the funds. They testified that they have a house as well as vehicles. No mention that they attempted to take out another mortgage or do anything like that, or that they reached out to other family members to see if they could get the funds. Additionally, I would argue that he is a danger to the victim because of what he testified to, that the last assault that he has was against this same victim. And so in order to protect that victim, I think the $50,000 bond is sufficient. I would also argue that he's a flight risk. He has a history of evading from the police. And taking his word for the reason why the prior company got off of his bond, I guess I won't get into that because let's assume that that's true, but he still has a history of fleeing. And so we think that the $50,000 bond is appropriate.
All right, Mr. Cucco, I'm gonna note that you've been in jail for over 400 days. I'll reduce your bond to $45,000. You're gonna remain on full GPS. the court will not remove the GPS based upon your history. Is there anything else with regards to the bond issue?
Nothing from the defense, Judge.
All right, then with that, we will close the record. Do you need to speak with Mr. Cucco, Mr. Ortman, in a breakout room?
No, I don't, Judge. I can reach out to him by video from here to the jail.
All right, has the evaluation been completed?
I'm not sure. I've spoken with the doctor who is conducting that evaluation. I haven't heard back since my initial contact with her, but I do know that, you know, she's required to complete it within, I believe it's 20 days, isn't it? So.
All right, yes. So is this a doctor that you had, or is this a doctor that was appointed through the court system?
Appointed through the court system.
All right, Norman, this is what I want to do on Mr. Cucco. Can we call this back in 3 weeks to see where we are on that evaluation?
Yes, ma'am.
So we're going to call you back, Mr. Cucco, to see where we are on the evaluation. And Mr. Ortman, have you received all the discovery on this case?
All that I know of, yes. Well, I'm going to say no, I haven't, because the complainant in this case, Crystal Simpson, she's made similar allegations against other people that it turned out to be just specious allegations. She's also made a number of material false statements to the police in this particular matter.
So you're saying you do not have all of the discovery?
Exactly, because
all right. So I don't, because there's going to end up being a back and forth about who said what. And the words of my grandmother, what she always say, who shot John? So instead of doing that, what we're going to do is we're going to call this case back. And at that time, let me know what discovery you do not have, confer with the state to see if they have the discovery that you're saying that you're entitled to that you don't have. And then we will hear that at that point in time. So we'll get an update on the evaluation and discovery. Norma, what date?
April 26th, Judge?
You say April 26th?
Yes.
All right, so we're going to come back on April 26th at 9 a.m. to see where we are.
Also, Judge, that related issue, ancillary issue of our investigator, he is investigating Ms. Simpson and her previous statements to police and others. And we've asked the court for a budget increase for him, that he needs to travel, for example, to Marion, Texas, not far from San Antonio, and interview witnesses.
All right, in order for me to consider approving an increase in investigator fees, I need some kind of documentation that he's already exceeded what I've given.
I have him here today and he could testify to that if you'd like.
I prefer it in a written motion because it needs to be documented, and having someone pull a court reporter's record, that's more expense for taxpayers because then someone has to pay the court reporter to do the record. And then there's added expense for you requesting it, getting the record. So that's where we are. Is there anything else?
No, that's it. That's over our objection, by the way, that we think that his sworn testimony would be sufficient. He's a former FBI agent. He could give the court the information you're asking for.
All right, court will take it in the form of written. So if he will file whatever he needs to file or whatever you need to file to show that he's exceeded the amount that's been given to him, and then the court will make a decision on whether or not to increase. And I believe Mr. Cucco, in the courtroom, you have a question for the court?
I'd like to speak to Mr. Sanders again. I was listening to his rebuttal and he misspoke.
Well, no, here's the thing, Mr. Cucco. The state, if there is something that they wish to discuss with you, then they will probably call you and seek your testimony as a witness.
Can you put us in a room, Judge?
Yes. All right. Mr. Ortman, I'm going to send you to a room with Marcus Sanders and with the witness in the courtroom.
I don't need to be there, Judge.
Okay.
Thank you.
All right. I'll send you to breakout room number 2, Marcus. And courtroom, if you can go to breakout room number 2, please.
And then I'll leave now, Judge.
Yes. And Norma, can you let them know that 14C can go back, please?
Yes, ma'am.
Eduardo Jimenez, what is happening with your client?
He has made a decision about what he would like to do.
What is he doing?
And, he was offered.
I don't want to know what he's offered because I don't get in the
plea bargain. Plea bargain. Yeah.
Oh, yeah, but still, I don't get the terms of the plea bargain agreement until actually I receive the paperwork on the plea bargain agreements, because otherwise, then I wouldn't be allowed to hear the case. And if your client were found guilty, then I would know what the previous plea bargain was. And ethically, I'm not allowed to know that. So if you will go to the breakout room number 3 with your client, if he's going to accept something, if you'll send that to the court coordinator what the agreement is, and she will get paperwork. If he's not going to accept anything, let us know and we'll bring him back.
Yes, ma'am.
All right, thank you.
Thank you.
Stacy Cross, your client is in the courtroom.
Yes, Judge. Nice surprise today, huh?
Yes.
I need to speak with him. Is that possible?
All right. As soon as the courtroom finishes speaking with Mr. Cucco, with Mr. Sanders, I will have you in the breakout room to speak with him.
Thank you, Judge.
Tom Nesbitt, any update on Miss Arcy?
Yeah, Judge, if we could do a breakout room with, if you could please, yourself, Mr. Simmons and myself.
All right, if you all will go back, let me see where you were. I'm going to move you all to breakout room number 9. So if you'll go to breakout room number 9, everyone just give me a moment.
Excuse me, is coordinator Norma Ferguson there anymore? Does anybody know?
I'm here.
Hi, Norma, how do we proceed to get the paperwork for the plea bargain?
I'm doing it right now. I'm doing the court's paperwork. The plea bargain paperwork comes from the prosecutors.
Okay, I don't remember which one we were conferring with, Damian Valdez.
Okay, I'll let David Martin know.
All right, David Martin
Okay,
should
thank you.
be on here. He's on here. Do you need to speak with David?
I just need to know, I guess, if you can put in the chat an email address and what, I think there were 2 separate offers made, which one they're going to accept.
Eduardo Jimenez, if you'll put in the chat box to David Martin, which agreement you're going to accept. If you can't put it in the chat box, I'll send you and David Martin to a breakout room together.
I can put it in the chat box, Sharon. Thank you.
All right, thank you.
Judge, can I see it in a breakout room?
Yes. Rebecca, what breakout room were you in?
I don't think I've been in one.
All right, I'll send you to breakout room number 8 and I'll meet you there.
Judge, can you send me to number 8 with you as well? I need to ask you a question.
All right, courtroom.
He paid her for the car. Yes, Your Honor.
Yes. Can you let, I'm going to send
There was no theft.
the defense attorney to number 2. If you can let Mr. Cucco know that if he wants to speak to the state, he'll have to make up another arrangements for that. I'm going to send Stacey Cross to number 2.
She's a smart, crafty woman.
All right, thank you.
Your Honor.
Stacey Cross, if you could go to 2, please. And then Ed Bartholomew. Yes.
Mr. Pompa, I believe he should be in the courtroom for surrender, and I think we need to sentence him today to his 5 years.
All right, let me see if he's there. Just give me a moment, okay?
Yes, ma'am.
And Judge, I'm sorry to interrupt. David Lunan said he was in agreement.
He was?
Yes, ma'am.
All right, thank you. All right, who is the prosecutor who's taking up Miss Lisa Flanagan?
I can.
Who said I can?
Joe Ray.
Okay. Court is calling 2018 CR 5085, State of Texas versus Lisa Diane Flanagan. Can I have parties announced for the record, please, for the state,
Joe Ray Garcia for the state.
for the defense?
Cornelius Cox.
Are you Miss Flanagan and you need to unmute?
Did I do it?
Yes. Are you Miss Flanagan?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
No, ma'am.
Any objection from the defense?
No, Your Honor.
All right, we are here for a motion for early termination that's been filed by the defense. Are both parties ready to proceed? State?
Yes.
And we're ready to.
You're not the state, Ms. Flanagan. To the state, are you ready to proceed on the motion for early termination?
Yes, Judge, we are.
Defense, are you ready to proceed?
Yes, Your Honor.
All right, defense, this is your motion. You may begin.
Okay. We'll call Lisa Flanagan.
All right, Ms. Flanagan, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand. State your name for the record, please.
Lisa Diane Flanagan.
Defense.
Okay, thank you, Judge. Ms. Flanagan, are you presently on probation out of the 187 District Court?
I am, yes.
Okay, and how long have you been on probation?
Almost 2 years.
Almost 2 years. And during that 2-year period of time, have you completed all the different conditions of probation that were set against you? Did you complete all your conditions of probation?
Yes, and I did it fast. Like
You did it fast?
Once she told me when she sentenced that I could get early termination at 1.5 years, I tried to get that in record time.
Okay. And is there, and not only did you do it in half, is there other reasons that you would like to be terminated from this probation? Any personal reasons in terms of things that you need to do in your life?
Well,
Or
if
do
we're
you
talking
just
about,
want?
I do have a new boyfriend. There's no violence or anything, but he had a stroke and he's in a coma, and I'd like to get to him.
Okay. All right. And in terms of your monetary obligations, in terms of your fees and stuff, are all those things up to date?
Yes, I paid it off. I paid it off in December, and it took them 5 months to get it to the court.
Okay. Okay. All right. I'll pass witness.
State.
Just a few questions, Judge. Ms. Flanagan, is CPS involved in your life?
No,
It's not involved in your life? You don't deal with CPS?
no, sir. And CPS was never involved in this case at all. And then also when I tried to call and ask if there was paperwork that needed to be like that to prove that you don't have a case. They said, if you don't have a case, we can't give you anything. CPS is not in my life. They never contacted me at all whatsoever. All I know is the DA and Randy and my daughter got together and talked about some stuff. The CPS never contacted me, nor did they start a case on me. And I have that on live recording from about a month ago when I discussed it with the chief of probation.
Okay, thank you. I have no further questions, Judge.
Okay.
Well, could somebody clear something up for me? Yesterday, she said that she could not be in court in the afternoon because her boyfriend transported physically challenged children. Am I imagining that?
No, ma'am.
So how is the person who
my
has a
witness
stroke is coming into
my estranged husband is the one that needed he was going to be the witness to be, because he's part of the victim part, but the new boyfriend had the stroke. That has nothing to do with that. So me and my estranged husband and the victim in this case are still very close, and he was going to testify to get me off of probation.
No, yesterday you said that you
yeah.
could not be here in court in the afternoon because your boyfriend had to transport, and you said handicapped children, and I said no. Are they physically challenged children? That's what I said. My mind is like a steel trap. You said that was your boyfriend.
So is mine. It's my husband, and it's Randy Zients, and he couldn't be here. Therefore, that's
what I'm telling you is, I don't know what you were thinking yesterday, but what you told the court yesterday was you could not be here and physically in the courtroom in the afternoon because your boyfriend was transporting children. That's what you said. You did not say my estranged husband is transporting children. You said your boyfriend was transporting children. And now you're saying that you can't do certain things because somebody's in the hospital. But I just want to make sure that my memory was correct. But
it was on my mind. But my ex-husband, well, not even my ex, my husband, he transports, he works for the school district. He could not be present. So that's why I wanted it in the morning for him to be present in case we needed him, because it's important to get those kids where they need to go. That's all I was trying to say. If I slipped on something, I'm sorry.
Mr. Cox?
Oh, yes, Your Honor. And I think probably she could have misspoke in terms of the connection, Judge. The ex-husband would have been the complainant in this case, and the state had made some mention that they had tried to contact him or something like that, and I think she just misspoke, Judge. But he was. I even talked to him on the telephone. It was actually her ex-husband, but the boyfriend is the one that's sick, Judge. So it's just a problem. I think she probably just misspoke, Judge. Probably just a little nervous and misspoke.
Mr. Cox, call your next witness.
I rest, Judge.
All right, State.
We have no witnesses, Judge. We rest.
All right, so State, are you in agreement with this early termination?
Judge, we spoke to defense. We aren't opposed. We discussed that. We'll leave it up to the court's discretion. I will state that there is a pending DWI case. However, the offense date is before the offense date of this case.
So the state is not opposed?
We're not opposed to their request.
So you're in agreement with early termination?
We're not opposed, Judge, but we're leaving to the discretion. We're not recommending either way.
All right. So here's the thing. This is what the court is going to do. Ms. Flanagan, do you have someone with you to drive you?
To drive me
Do
where?
you have abilities to go somewhere?
I do.
All right. So, Mr. Cox, this is what I want. I want your client to provide the court with a UA. Ms.
Okay.
Cox,
Yes, ma'am.
I want your client to provide the court with a UA, and based upon that UA, then the court will make a decision.
Okay. And Judge, oh, I'm sorry, I'm back.
Can I do that tomorrow?
Ms. Flanagan.
No, it has to be done today. That UA will be done today.
Where?
They will tell you where you need to go.
Okay. Yeah, and I just wanted one thing clear, Judge. I think there was she had always complied with UAs. I think they've taken them over the period of her probation, and I don't believe, Judge, that she's ever come back dirty with a UA.
Right.
I just want we didn't mention that, Judge. I don't think in probation can say that she's never had a dirty UA since she's been on probation.
I have something to say.
Do it, Judge.
All right, here's the
Can I
thing.
say
I don't need to hear anything else. This is what's going to end up happening. You're going to go do a UA today. We will see what the results for that UA will be. I'm going to send you to a breakout room to speak. Rebecca, can you go to breakout room number 4 and set Ms. Flanagan up with a UA today?
Yes, ma'am.
All right.
And
Mr.
can you send her officer in there as well?
Yes. Who's the officer for Ms. Flanagan?
Listed under Linda Navarro.
No, it's Escobar.
It's Derek Escobar, Your Honor.
Right. Ms. Flanagan, I was just saying he's listed under Linda Navarro.
Sending you to breakout room number 4. So please go to breakout room number 4.
So I push join?
Yes.
Thank you, Judge.
You're welcome.
Your Honor.
Just give me one moment. All right, Ed Bartholomew.
Is my client in the courtroom?
Yes. Could you please unmute?
Yes, Your Honor.
All right. And Ed Bartholomew, what is your client's name?
My client's name is Mr. Pompa.
All right. Are you Mr. Pompa?
No, Your Honor. Mr. Pompa is not in the courtroom.
All right. We're waiting for Mr. Pompa. Ed.
I believe he was there. He might be out in the hall. Let me call him, Your Honor. I'm sorry. I'll have to run him down.
No problem. Bill Simmons.
Thank you.
Yes, Your Honor. May I be please placed in the breakout room briefly with my client, Mrs. Arcy?
Send you to breakout room number 2.
Thank you, Judge.
You're welcome. All right, Stacy Cross.
Yes, Judge. I've discussed this with Alexandra and with my client, and we are going to ask for a bond to be set right now, Judge.
Is there an agreement on the bond?
Judge, Alexandra has told me what she's going to ask for, and I'm going to ask for something different, but it's, everything is reasonable here. None of us are being crazy here.
All right, to the clerks in the back, can I please have the files on Mr. Suarez, please? 2020 CR 5268 and 4568, please. Mr. Eduardo Jimenez.
Yes, Judge.
Yes. What are we doing with your client?
Again, there's a plea bargain, Your Honor, and I'm just waiting on paperwork. I think I sent paperwork to the court coordinator that came through, Ms. Ferguson, and I haven't seen any other paperwork yet.
The plea paperwork should be coming around.
All right. Yes. All right, so before I hear your arguments, I just want to let you know that this court is the one that remanded him without bond. And it was the second time that he no-showed. So is everyone aware of that before we ask what we're going to ask for?
Yes, Judge, I'm aware. I was present when that happened, and there's an explanation. Do you want to hear it right now, or you want to wait?
Give me a moment.
Okay.
Court is calling 2020 CR 4568 and 2020 CR 5268, State of Texas versus Suarez. Can I have parties announced for the record, please, for the state?
Alexandra Williamson.
For the defense?
Stacy Krause on behalf of Raul Suarez.
All right. The defendant was, I guess he appeared in the courtroom and there was a remand without bond. So we're here to have the court consider setting a bond for Mr. Suarez. Are both parties ready to proceed?
Here. Yes, Your Honor.
All right, and we are proceeding by video because of the pandemic. Any objections from the state or the defense?
No, Your Honor.
No, Your Honor.
Court will note that the defendant is in the courtroom. This is one of the days the court is allowed to have in-person hearings. State, what are you requesting for on a bond in each of the cases?
Your Honor, his original bonds were $4,000 on each case. And although we are aware that he has failed to appear both times, I think him turning himself in today and wanting to resolve these cases, the state would be okay with a $4,000 bond on each case.
Defense?
Okay, Judge, thank you. So the failing to appear was back in October. I had gotten appointed to his cases through the wheel, and I had not been able to reach him through any of the phone numbers that I had or through his bondsman. But he apparently was in contact with his bondsman, and they did not tell him that he had that October court date when he failed to appear. And you know, unfortunately, he didn't contact me either. I guess he didn't know I was his attorney at the time because, like I said, I was appointed on the wheel, off the wheel. But his bondsman eventually did tell him he had warrants, and then he was able to call and find out I was his attorney, and he contacted me, and that was in February, Judge. And I have had constant communication with him. We have been trying to figure out how to resolve this bond issue since then with his bondsman. Ultimately, we weren't able to resolve anything where his bondsman was willing to go back on his bonds, which is what we were ultimately trying to achieve with this. But this wasn't an intentional failure on his part to try to avoid, coming to court and avoid these cases at all. He appears for his court dates as he's required to do when he's aware of them. He just, with the pandemic and everything else, something happened where there was just miscommunications. But he did turn himself in today. He wants additional time to figure out how we're going to resolve the cases because there is still some due diligence I need to do on my part. I have been in contact with Alexandra on this issue. We actually talked about this earlier this month, earlier in March. So we've been trying to work this out as well, Judge. And so I'm just asking, I'm asking for bonds to be set as low as possible, or even if you were to consider PR bonds, given that he did post those $4,000 bonds, he is still paying his bondsman for those bonds. And so he is, even though they're not willing to go back on the bonds, he's still paying for those. And so I'm just asking, for some kind of consideration for, just miscommunications that happened.
All right, so why didn't you've addressed the October issue, but again, October is the second time he didn't appear.
Right, the first time is probably, I don't know when the first time was it before I was appointed?
It was in June.
Okay, oh, in June I got the offer, right? And I got a note that the client didn't need to be present in June, and I still had not had contact with him at that point, Judge. So the first time I had contact with him was when he contacted me after his bondsman informed him he had warrants. So I just believe he didn't know I was his attorney.
All right, and each of the cause numbers, I'm going to set the bond at $4,000. Mr. Raul Suarez, it's your duty to keep up when your court dates are, not your bondsman. All it takes is a simple phone call to the clerk. Yes.
Ma'am, I just wanted to let you know that I actually have paid off all bonds, and I was always calling, but this was in the pandemic and then the freeze. I called every other week asking.
There was no freeze in June.
No, this is before when all the pandemic started with the COVID, when we weren't having court.
Yes, we were, because I was here in June, and it's written in the file on the docketing sheet. You did not show up June, and in June there was no freeze. So
I can't understand why whenever I bonded out and my bonds people didn't have a court date for me. And every time I called to the courthouse, they didn't have a court date for me. They said to keep calling, that they would let me know or send me something.
Now, the clerk would not have told you that in this courtroom because it's in the system that your date was for June and you did not appear. And at that time, I did not issue a bond forfeiture for you. I told your attorney, we will come back on October 13th and we'll see if she can get in touch with you. And again, you did not show up on October 13th. I think the lesson learned or that you should take forth going forward is one, you need to keep in touch with your attorney so you'll know when your court date is, and you need to call the court 335-2517 so they'll let you know when your court date is. Guess what? When all people have all these different people that they're having them tell them whether they have to be in court or not, those are not people who end up doing time at the Bexar County Jail, right? So now your bondsman is not at the Bexar County Jail and you're saying your bondsman told you you didn't have to Zoom in or have to appear, but your bondsman is not at the Bexar County Jail. So what I can tell you is the court has gave you 2 times to appear and you did not. All right. All right, good luck to you.
Thank you, Judge. I'll be in touch with you.
Just one second. Norma, before we go, Norma, give Mr. Suarez a new court date.
May 6th, Judge.
May when?
The 6th.
All right, so Mr. Suarez, your day is May 6th. You're going to get a reset form May 6th. If your bondsman tells you it's not May 6th, you still had better be here May 6th. Do you understand?
Yes, ma'am. Come in next week.
All right. If there's nothing else, you are excused, Ms. Cross. Ms. Cross, thanks for coming in.
Thank you, Judge. Thanks for letting me know. Raul, I will be in touch at the beginning of next week, okay?
Thank you, Ms. Cross.
Okay.
I think next week will be the week. Let's
okay.
Do that.
Thank you.
Thank
okay.
You.
Thank you. Bye-bye. Thank you. Could you get that to bigger for me? Thank you. All right, and who is the attorney on Carlos Landon? Have they came here yet?
Judge, I am here, waiting with bated breath.
Oh my gosh, you know, when your video is not up, it's like, I don't see you on the screen.
Well, Judge, I didn't want to make it scarier than it needed to be.
Okay, all right, and Rebecca, on Arce, Norma?
Yes, ma'am.
I'm gonna send you to a breakout room with Bill Simmons and his client so you can get her email address.
Okay.
And what they're gonna need is a consent to plea. It's a motion to revoke and also a trial court certification.
Okay, thank you.
All right, so I sent you to number 2.
Just Norma, right?
Yes.
Okay.
Okay.
All right,
One
and
second.
let me find your client, just 1 second. To the clerks in the back, could I get the file, please, on Landon? Lupe, strike that. I don't think there is a file on him. John Coates, you here?
Yes, ma'am. My client and I just went over all the plea paperwork. She just needs to be sworn. I don't see Lupe. Is Lupe on? Oh, there he is. 187th clerk Lupe.
All right, where's your client?
She's probably still in the breakout room.
All right, I'll send the clerk to breakout room number 1.
Thank you, Judge.
Thank you. Andrew Del Cueto.
John Kuntz.
That's just, so you don't even go by a first name, you just go by Zoom user Del Cueto? It should be taco user Del Cueto.
I'd rather go by Ghetto Cueto.
All right, Andrew, have you had a chance to confer with the state on Carlos Landon?
I have not, Your Honor.
All right, who is the prosecutor who will be on Carlos Landon? We have a violation report. And there's also a motion to authorize lowest breath volume setting on admission interlock device.
I don't know that there's much.
Oh, Tom, you're muted.
I mean, I'm aware of the fact scenario.
All right, so do y'all need to confer or no?
No.
Okay. All righty, then we will take her up. Is this going to be agreed to or not agreed to?
I think we just want to explain the situation, Judge, and get your authorization. I'm not trying to speak out of turn for Mr. Nesbitt, to lower the breath volume needed for a reading.
So are you guys in agreement to that or no?
Yeah, basically the person is.
Let me see you guys in a breakout room, please.
Yes, Judge.
Just give me one moment. All right. Del Cueto, if you'll go to breakout room number 4, and Tom, I'll meet you in 4. All right, so everyone else, I'm just waiting for paperwork. And then we'll go forward.
Judge, this is Eduardo Jimenez. I don't know. My client told me he signed everything on his side and I signed on mine, so I don't know if we're in, our standing, our status at this moment.
Well, your client, I'll send her to breakout room number 1. I'll send you to breakout room number 1. The clerk is in breakout room number 1, and you can see if the documents have been signed. Okay. And on the Landon, the attorney needs an email sent to him of that order. All right, thank you. Who are the prosecutors on Orozco?
Marcus.
Court is calling 2021 CR 2981, State of Texas versus Michelle Marie Orozco. Could I have parties announced for the record, please, for the state?
Marcus Sanders.
For the defense?
John Coons for Miss Orozco.
And are you Miss Orozco?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state or the defense?
No objection.
No objection, Judge.
No.
Ms. Orozco, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes,
I
ma'am.
have your, yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Orozco, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor, and they're actually waiving the habitual count.
State, are you proceeding on the indictment as presented?
No, Judge, we're waiving the enhancement paragraph.
Any objection?
No, we're very grateful.
Ms. Orozco, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with? The possession of a controlled substance penalty group 1 less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Both.
Do you believe she's currently competent and was legally sane at the time of the offense?
Most certainly.
Ms. Orozco, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 73 days in the Bexar County Jail under 12.44 of the Penal Code. There are no applications for community supervision or deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, pardon me, it is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand
ma'am.
it?
Yes,
Did you
ma'am.
electronically sign it in both places?
Yes, ma'am.
Do you understand by signing that you're waiving your right to appeal? The only items to be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then Ms. Orozco, to the offense is charged. How do you plead? Guilty, not guilty, and no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, the state offers State's Exhibit 1 and its attachments.
Any
We've
objections?
reviewed them and have no objection, Your Honor.
Ms. Orozco, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it?
Yes,
And did
ma'am.
you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Are we proceeding with sentencing?
We'd request that, Your Honor. We'd request that you follow the plea bargain and give her judgment satisfied on this case.
All right, the court will find you guilty. The court will sentence you to 73 days in the Bexar County Jail under 12.44 of the Penal Code. Give you credit for any time served. Is this a judgment satisfied?
Yes.
Yes, Judge.
Court will find that the judgment is satisfied. Next, I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that?
Yes, ma'am.
Attorney, did you understand it and did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Ms. Orozco, how old are you?
I'm 47, ma'am.
All right, Ms. Orozco, here's the thing. You're either going to spend the rest of your life in and out of the Bexar County Jail or somebody's county jail or in and out of prison if you continue how you're going. You understand?
Yes, ma'am.
I'm sure your attorney has probably told you there are a lot of places that can help you. If you have a drug addiction, they can help you. If you need housing, they can help you. But they can't help you if you don't reach out and try to seek help and if you continue to live the life the way you're living it. You understand?
Yes, ma'am.
Do you have children?
Yes, they're grown, but yes,
All
I
right.
do.
So here's the thing. You still want your children to look up to you. So you need to become a role model, okay?
Thank you, ma'am. Thank you.
All right. Good luck to you, Miss Orozco.
Thank you. You too, ma'am. But thank
Thank
you.
you, guys. Have a
Bye.
happy Easter, everyone. Take care.
All right. You too. Happy Easter.
Thank you. Michelle, I'll call your family.
Okay. Thank you, sir.
You're welcome. Take care.
You too. Bye-bye. Oh, she's a nice judge.
All right. Norma, can you let them know that L20 can go back?
Yes, ma'am.
Thank you. Is anybody else ready? Deputy Laura, is there Mr. Pompa in the courtroom yet?
No, Your Honor.
All right.
There's nobody here.
All right. Norma, see if you can get Mr. Bartholomew back on the screen, please.
Yes, ma'am.
And there's no one in the hallway.
All right, thank you. But Brenda, is there anyone at the convenience store
Probably.
or at the HEB?
Yeah.
I'm actually at HEB.
Okay. Oh, Mr. Simmons. So have you received the paperwork on Miss Arcy?
I have, Your Honor. If I could have, if Mr. Nesbitt's available for a brief conversation, Judge, very
All
brief.
right. I'll see you number 3.
Yes, Judge.
But Bill, you know, as attorneys, the question is, what do you mean by brief? Is it like 2 minutes, 3 minutes?
He left.
I suspect it's going to be a 2-letter word.
Okay. I don't know what that 2-letter word could be. Ah, I do. 2-letter word. Okay. All right. Norma, did you receive that email that I sent to you?
Which one, Judge?
The one that a clerk sent asking about an update.
Let me check on it.
All right, thank you.
Judge, I'm gonna step away for a minute.
All right, thank you.
Judge, that's on Suarez case. They were gonna CC you on it, just to let you know that they're asking. The clerk is asking when that report's gonna be ready.
Okay, all right, thank you.
You are.
All right, thank you. And have you sworn her in, Lupe? All right, it's already been signed. Oh, and Norma on Flanagan.
Yes, ma'am.
Oh, we'll just wait till Mr. Cox wants that recalled.
Okay.
But we need to get her UA.
I also called Doug Campbell. He said his client's not coming in.
Yeah, Doug Campbell needs to zoom in.
Okay.
All right, thank you. All right, Mr. Simmons, you're back.
Yes, Your Honor. Mr. Nesbitt is logging back in, and we're, if with the court's permission, would like to go in a breakout room, the same breakout room left for my client. She's in 3, and I've agreed that we can all be in the same room so she can hear what's going on. She has certain opinions. But she's already in that breakout room, so I don't know if she needs to come out of it. I was in breakout room.
No, I'll put her in breakout room number 2. Who do you want to go to breakout room number 2?
Me and Mr. Nesbitt agreed to, if he's still okay with that.
Okay, all right. I've sent. Am I to come to breakout room number 2 or no?
I don't want to. No.
Okay.
No,
All right. I've sent you both to breakout room number 2 then. Norma, I don't know if I'm going to get run out of Texas, but today was the first day that I ever had a churro.
I love churros. Those are my favorite. Where'd you get it from?
Deputy Laura brought it to me. She's like, here, have a churro. I'm like, I've never had a churro.
You've never had one? Those are the best.
So she was stunned. So I'm blaming you for my lack of knowledge of the churro.
I don't bring them because I'll eat them. That's why. They're so good.
And then Michelle brought me corn in a cup. I never had corn in a cup. Very good.
Judge Campbell said he's in CPS court right now. He'll be done in about 15 minutes.
Okay. All right, Eduardo Jimenez, I believe we're ready on your client.
All right, Judge, good.
This is Darlene, the management doctor in this office. And
David Martin?
Yep.
All right, could you start your video for me, please? There we
I
go.
did. Thought I did. Yeah.
All right, Mr. Valdez, could you unmute for me, please?
Yes, ma'am.
All
Yes,
right,
Judge.
thank you. Court is calling 2019 CR 10960 State of Texas versus Damian Valdez. Could I have parties announced for the record, please, for the state,
David Martin.
for the defense?
Eduardo Jimenez.
And are you Mr. Valdez?
Yes, ma'am, I am.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Valdez, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Attorney, I did.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, I did.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I'm sorry, I did. Yes.
Court will find that the state is in compliance with discovery. Mr. Valdez, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, I do, Judge.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Valdez, I'm showing you a document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor, I did.
Did you understand what you're charged with is sexual assault of a child? That the second degree felony, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Valdez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court would find the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement, your punishment is to be assessed at a cap of 8 years in the prison. There's an affirmative finding that you're not eligible for anything other than deferred adjudication. The state will remain silent on your deferred adjudication. And there's Chapter 62 compliance. Did you understand with this offense, you're required to register as a sex offender for life? Did you understand?
Yes, Your Honor.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Mr. Valdez, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Then to the offenses charging an indictment, how do you plead? Guilty, not guilty, or no contest?
No content, Your Honor.
State any evidence to support the defendant's no contest plea.
We'll offer states one in the attachments.
Any objections?
No objections.
Mr. Valdez, I'm showing you a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you have a chance to review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
The court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Norma, when can we come back on this for sentencing?
April 30th, Judge.
All right, Mr. Valdez, we will see you back here on April 30th. At that time, the court will make a decision on your application based upon a PSI report and any other evidence that's presented to me. Do you understand?
Yes, Your Honor.
All right, I'm gonna send you to a breakout room with probation. Probation will go over instructions with you. I'll send you to breakout room number 3. Mr. Jimenez, I'll send you to 3. After that, you're excused.
Thank you,
Thank you,
Judge.
Your Honor.
You're welcome. All right. Doug Campbell,
Yes, ma'am.
where is Mr. Carlos Vasquez?
I have no clue. I've instructed him that he needs to present himself to the court and sign his paperwork, and I have no clue where he is.
Okay. All right, Brenda, we're gonna go on the record briefly. Court is calling 2021 CR 2691 and 2021 CR 0827, State of Texas versus Carlos Alfredo Vasquez. Can I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Doug Campbell for Carlos Vasquez.
All right, we had a hearing on this case yesterday, March 31st. It was recalled for 1:30 p.m. The defendant was on Zoom. It was requested that the court give the defendant a PR bond, and the court did give the defendant a PR bond and admonished the defendant on his new case, gave him his magistrate warnings, and instructed the defendant to appear in court today. Deputy Laura, has there been a Carlos Alfredo Vasquez in the courtroom at all?
No, Your Honor, he has not.
Has he been in the courtroom this morning or this afternoon?
No, Your Honor.
All right, thank you. And he has not been on Zoom. Defense, have you had any contact with Mr. Vasquez since yesterday?
I have, Your Honor. We instructed him to make himself appear in court, and he's aware he needs to be there.
State?
Judge, we are asking that you forfeit his bond and issue a warrant.
All right, that'll be granted, and I will remand your client without bond. If your client has a reason for his failure to appear, of course, the court will be open to hear that. Thank you for coming in, Mr. Campbell.
Sorry, my client didn't show up, Your Honor. Have a good.
All right, thank you. You too.
Bye-bye.
Bye-bye.
They're always locking them. They're not always-
Judge Eduardo Jimenez here. I think my client is not going into the breakout room. I don't think maybe he doesn't know how, or he didn't understand.
Mr. Valdez, do you see the boxes at the bottom of your screen that say breakout?
Yes, ma'am.
Click on that. Do you see where it's requesting that you go to a breakout room, number 3?
Yes, Your Honor.
Click on that. Mr. Bartholomew, do you know where your client is?
I saw him, Your Honor. He was checking in 2 minutes ago. He probably is walking through your doors.
All right, Deputy Laura, Deputy Mejia, is there a Mr. Pompa in the courtroom?
No, Your Honor.
He was checking through security. He just got off the phone with me 3 minutes ago.
All right, we'll wait.
Thank you. I think it is a sentencing, isn't it, Judge?
Yes.
Thank you. I'm on standby, Your Honor.
All right, thank you.
Perhaps he was having an Easter meal, Judge.
I think it may be, a little bit early for that. I could be wrong.
Well, but he won't be available for it because I believe his is a to-do. I think.
Okay.
Thank you, Judge.
Norma, any update on Jahagan Alexander? You're muted, Norma.
Yes, ma'am. I'm looking through my paperwork. Give me 1 second.
Thank you.
Judge, she says she's still in the CPS hearing. If it can get recalled.
Well, no, tell her no, because her client is not here.
Judge, I'm done with Mr. Valdez.
All right, thank you. Norman, can you let them know that 14A can be excused?
Yes, ma'am.
Thank you. And Rebecca, I'm signing paperwork that you sent me.
Okay, thank you.
Yes, sir. I'm right here.
And then on one of the documents that you sent me, I have a question about. And I don't believe it will let me not sign it.
On those, I always put that other box where you have to type in your name.
Okay, let me see.
That might be it.
No, it won't let me do it.
Oh.
This is one for early termination. It's on Gerald Benitez.
It's not letting you sign the last page or the
last page, but I've already, I said no, but I wanted to put in there to resubmit. Because usually there's a space for me to do that.
Oh, okay. I don't know why it didn't let you.
Yeah.
I put a blank box in there.
I don't know. I think because it's a Monday on a Thursday. All right, Mr. Pompa.
You can get closer.
Okay.
Hello, thanks for making it.
I'm sorry, man. I kind of had a bad night last night as far as my pain, and I took a extra dose of pain medication, and I woke up late, and of course I had to get everything ready as far as my medication goes and stuff, that sort, and they were just everywhere. And
he has his meds with him.
I wasn't. How do you say? I mean, I was ready to come in, but I just wasn't ready.
Ready.
Yeah, ready.
We're not ready because you need to gather your things. All right, no problem. I understand.
I'm here, Ms.
And Your Honor, on the table will be his meds, I believe, in that plastic bag that he's prescribed.
Okay. All right, we'll make sure those go with you. I don't know how that works at the Bexar County Jail. I think they will probably take them, but I don't know if they will give them to you.
Until I see their doctor, maybe.
Yes. So Deputy Laura, can you make sure that they're aware that he's on medications?
Yes, ma'am.
All right, thank you. Who's the prosecutor you're working with on this, Mr.
It would be Mr. Nesbitt.
Okay. Court is calling 2018 CR 9362, State of Texas versus Robert Lee Pompa. Could I have parties announced for the record for the state? Tom, you're muted.
Tom Nisbet.
For the defense?
Senator Bartolome on behalf of Mr. Pompa, Your Honor, Mr. Pompa present on bond, ready, and waiver signed, Your Honor, for sentencing.
All right, Mr. Pompa entered a plea of true to violation of condition number 2 on January 6, 2020. The court found it true. Then it was reset for February 3rd. Then the defendant was shot, so it was reset for March the 3rd, and then it was recalled for April 1st. So is there an agreement?
There is, Judge.
And what is the agreement?
Revoke and adjudicate 5 years, Texas Department of Corrections, credit for time served.
Defense, is that the agreement?
It's our understanding of the agreement and my clients, Your Honor, at this time.
Mr. Pompa, are you asking that the court follow that plea bargain agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am. I'm waiving my right to appeal.
All right, then the court will follow your plea bargain agreement, sentence you to 5 years in the prison, give you credit for any time served. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Pompa, good luck to you, okay?
Yes, ma'am. Thank you very much.
All right, let me ask, did he do any inpatient treatment?
Robert, have you done any inpatient treatment?
I was doing it, it's not until I got my revocation. But
Well, I see where he was ordered to safety. Did he complete that, Rebecca?
I think that's when he violated.
Yeah.
Ah, so he didn't complete safety.
no, man, I didn't complete the full program. No, man.
Why were you released from safety?
I did a year, almost a year, doing the classes and stuff of that sort.
No, that sounds like intensive outpatient treatment. So I'm trying to figure out if he actually did the 9 months of safety or not.
Yes, ma'am. I did 6 months AP, 3 months aftercare in the Austin halfway house, and then was released to my home in March. On March
last year.
Yeah, last year.
All right, I'll give him credit for any time that he was on lockdown in safety.
Thank you, Your Honor.
All right, so because this is a.
Can I ask one other question? I apologize.
Yes.
Was it your Austin time, was that inpatient, lockdown, or outpatient, free to come and go?
It was outpatient. It was inpatient. I would say I had to stay there for 90 days, but I was allowed to leave work.
Okay.
But I had
So
to,
you weren't totally confined, is what I meant.
Yeah.
Yeah.
All
And
right.
if he did not complete the aftercare program that was inpatient but not at the prison, I won't give him credit for that. But I will give him credit for the time he was at the prison for safety.
I was just hoping it was all confined, Your Honor, in the halfway house. Thank you, Judge.
You're welcome. All right, Mr. Pompa, because you reached a plea bargain agreement, because I followed that plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
no, I do.
And also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am. I do.
All right, good luck to you, Mr. Pompa. We can go off the record. Mr. Pompa, you need to start changing your life. Otherwise, it may not turn out so great. You understand?
Yes, ma'am. I know my other two options will either be life in prison or dead. So
yes.
Well, he has 5 good reasons, Judge, to consider changing his life. I think you'll carry those with him for a while.
All right, make it happen, Mr. Pompa, okay?
Thank you.
All right, you're welcome. Good luck to you.
Thank you, Judge.
All right, bye-bye. Thank you,
Happy
Mr.
Easter, y'all.
Buckland.
Sorry that you had to
Hey.
wait so long.
Oh, I'm here till 5. Thank you. Have a good one.
Thanks, Tom.
All right, do we know what is happening with Tony Arcy? All right, I'm closing the breakout rooms, so everybody will come to the main room. They have 60 seconds. And then after we end for today, I'm going to need the prosecutors to remain after we conclude Zoom. There are 2 of those that's a bond forfeiture to remain without bond.
So, and I'll put the paperwork in the file, the one for the magistration. The magistrate,
Yes.
you can file,
Yes,
okay?
but that bond forfeiture on that.
Yeah,
remain
I
without bond.
understand that. So put it in the file.
All right, thank you.
And I'll issue it.
Thank you. Thank you. All right, Mr. Simmons, what are we doing with Miss Arcy?
Your Honor, she's going to we're going to move forward with the MTR and the offer.
All right, has she received all the paperwork?
Let me check, Judge.
Miss Arcy, did you
She'll have that.
receive-
She'll have that momentarily, Judge, because I just need to sign it very quickly. I was speaking with her.
Okay.
Yes, ma'am.
As it relates to the appeal, Judge, there's also an agreement of no appeal on this.
All right, thank you.
Judge, and
Hey, Lupe.
so Mrs.
On the one of the paperwork, are you busy? Um,
Norma,
Yes, ma'am.
on Jahagan Alexander, recall that for Monday. And if
Okay.
the defense attorney does not appear, we're going to appoint someone else.
Okay, thank you.
and Judge, that's been submitted. We're just waiting for the client to get it back, Judge.
Okay.
Oh, do I need to go sign something? Or
You have two
I'm
documents.
calling you right now,
need to sign.
I'm calling you right now, Miss Arcy.
Okay, it's completed.
Okay, Ms. Arcy, the court will let us know. You can mute.
Rebecca, on that case, has the motion to revoke been sent?
Yes, ma'am.
All right, has it been
Nice.
signed?
It said it was signed.
Okay. So we'll be ready to go.
I'll double check again. I thought I sent it to the clerks.
Judge, what's the case number?
It's 2019 CR 0543W.
Thank you, Judge. I'll check right now.
All right, and Norma, do you know where Myra Santos is?
Give me 1 second, Judge.
Thank you. Rebecca, has the motion to revoke come back to you? Can you just send it to me, to my email, please?
Yes, ma'am.
Thank you. All right, Lupe, she's sending it to me. Can you just print out the trial court certification, please? And the consent for video?
Yes, ma'am.
No, I didn't stamp. All right, Miss Arcy, I need you to show your video and unmute.
Yes, ma'am.
All right, is there a prosecutor available? Court is calling 2019 CR 0543W State of Texas versus Tony Arcy. Could I have parties announced for the record for the state,
Tom Nisbet.
for the defense?
Attorney Bill Simmons.
All right, and are you Miss Arcy?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state or the defense?
No objections.
Miss Arcy, did you sign a document entitled Defendant's Consent to Appear by Video?
Yes, I did.
And did you go over that document with your attorney and did you understand it?
Yes, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Your Honor, I read it to her, Judge, in terms of what the allegation would be, which is to not submitting for the drug test, Judge.
Ms. Arcy, did you review that document with your attorney and did you understand it?
Yes, ma'am.
Are you the same Tony Gabriel Arcy who was placed on deferred adjudication in 2019 CR 0543W for the offense of abandoning or endangering a child with intent to return on January 22nd, 2019 for a period of 2 years and extended for a year?
Yes. Yes, Your Honor.
State.
Condition number 2, on or about the 25th day of March, 2021, Bexar County, Texas. The defendant, Tony Gabriel Arcy, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that, true or not true? How do you plead to that, true or not true?
True.
Well, don't act like you don't know. Did you go over this document with your attorney? Yes or no?
I mean, yes, I did.
So are you pleading true to a violation of condition number 2, yes or no?
Yes, ma'am. I'm sorry, I'm a little distraught.
Well, I don't understand why you're distraught. Why are you distraught?
I'd rather not speak about it.
All right, well, we don't have to do this today. No one's forcing you to do this. Because according to my last condition for you, you were supposed to take a drug test and you're not submitting for your drug test. So if you don't want to proceed with this, we don't have to proceed with this. State will file the motion to enter adjudication of guilt. The court will set a bond for you. You'll be
arrested.
arrested.
Why I signed this. That's why I signed this so that I didn't have to go through that.
So,
Ms. Arcy, if it pleases the court, Judge, could I, Ms. Arcy, with the condition, again, on or about the 25th day of the March 2021, that's what we talked about in terms of the violation of your probation is not doing the drug test. So are you pleading true to not taking the drug test?
Yes.
And that's all the judge is asking you. Remember, we said all you have to do is say it's true. My suggestion is unless the court asks you a question directly, you not volunteer anything else, okay?
Okay.
Mr. Simmons, is there an issue going on with your client?
Not as it relates to this. Well, I'll just say my client would like to proceed. She's just, I guess the best way to say it is that we're not getting exactly what we want. So there's some hesitancy there, but I mean, that's life, and that's been explained. I would say that's the source of the hesitancy at this point, Judge. Not anything legal. Would you agree with that, Ms. Arcy?
Yes, I would completely agree with that.
Okay.
I mean, because we don't have to do any of this. Why are you drinking? What are you drinking?
I am drinking coffee.
All right. How old is your client?
She's about 30 years old, Judge.
Okay, why is she acting like she's a 16-year-old or an 18-year-old?
Judge, she's, well, I would say this did catch her off guard a bit because we thought it would be treated as a motion. And then when she had a compliance hearing, she said that she didn't know about the compliance hearing today. And so when I got the credentials, I said, so I think it's more just being caught off guard with the situation as a whole,
And the reason
not
why
knowing that she was addressing it today.
All right, and the reason why she had a compliance hearing is because she won't follow the rules of the court. I mean, how hard is it to go do a UA? Unless you're afraid that the UA is going to be positive for drugs.
Were you asking me, Judge?
Yes, I mean, it's not rhetorical. I'm throwing it out there at her. Like, how hard is it for somebody to do a UA? She could have had a compliance hearing, which is designed for me to get her attention to tell her, you need to go do this UA. Or I could have just signed the motion to revoke, which is what everybody else wanted to do, which is what probation presented to me. So I don't know why she's acting like this is being caught, like she's caught off guard, like she's walking around without an umbrella and all of a sudden it starts raining. She already knew the storm was coming because she wasn't doing what she's supposed to be doing while she's on probation, which is very simple, which is take a drug test, don't use drugs. And she entered into a plea to this January 22nd. And we had a hearing on August 13th because, again, picking up new cases and not taking drug tests. Then we had a hearing on September 5th. Why? Because she won't take a drug test. So
I did take
now
a
we're
drug
back here. Then we had March 12th. She was supposed to submit to a UA by 3 p.m. and she didn't do it. So I don't know why she's acting like she was caught outside without an umbrella when she knew this rain was coming.
I did submit that UA by 3 p.m. I did.
Your Honor, and I don't want to make it seem like I was just, in terms of her general, the court had inquired about her, just kind of the general demeanor. And I was just saying some of it's caught her a bit off guard. I was just saying in terms of what's actually happening today. But a very, very thorough cost benefit analysis, both legally and personally, has been addressed to get us to this point.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
To an extent.
All right, this is what we're going to do. Mr. Simmons,
yes,
I'm going to open up a breakout room. You can speak to your client. I'll send her to breakout room number 1.
Yes, Judge.
Oscar Hernandez.
Yes, Judge.
Hello. Who are you here for?
I am back again on the pretrial services violation for Myra Santos.
Right, she's not on the screen.
She was earlier, got disconnected. I asked the mom to help her call. She's the lady I've advised the court that doesn't have a cell phone, doesn't have internet at the house, and she has a mental deficiency, which is the reason I argued for mental health services at the bond hearing. And it was granted. And after all that exchange of this violation report and emails with the pretrial services, we did a 3-way call and we were able to speak to her. The issue with what I read from the pretrial service violation report is that the trunk number they have for her is incorrect. So when they say they call and leave text messages, it is not getting to her whatsoever. The only family member that has a cell phone is a Spanish-speaking mother who I end up calling and texting while she's at work.
So is that Angelica Santos or Angelica Katie?
Angelica Santos is the mother. Angelica Katie is a sister who does not live in the same residence and has little to any contact with the defendant. I spoke to her and she seemed
He's frozen. It's a Monday kind of a day, but we're still gonna make it feel like it's Thursday and it's gonna be a Friday. Oscar Hernandez, are you unfrozen now?
Hey guys, 30% of the time, well, I think that.
Looks like Oscar's back, Judge.
Hi, Oscar.
Hi, Judge. I could still hear you, but I heard you say that I was frozen.
Yes, so the 771 number, is that her mother's number?
I apologize. I will check my messages. But from the violation report, Judge, that they did have the correct mother's number listed under Angelica Santos.
Okay, this is what I'm going to do. I'm going to give her until Tuesday to get in touch with them. And if she does not, then we will be where we are.
Thank you, Judge. But my understanding is we all spoke on a three-way after they sent that violation report, Judge. And so they were gonna have her report the next day by Zoom, and I have not heard that she did not on a Wednesday. So
all right, I'll put on here by April 6th. So if she's reported, then they will send me notice that she's reported.
Beautiful. Thank you very, very much, Judge.
All right, thank you. Have a good one.
Thank you. Bye-bye.
Bye-bye. Norma, what day do you want to put Adrian Garcia on for recall? For competency?
I'm sorry, Judge. I think you said on Wednesday?
No, I haven't given a date. We were trying to see what date. We've received the emails back and forth.
Yes, ma'am.
And they say that he's not been scheduled.
Okay. Do you want to bring back in 30 days?
Yes, let's say 30 days.
We can do April 30th.
All right, April 30th it is. Oh, are you ready, Mr.
Yes, Judge.
Simmons?
Whatever court is my client, she should be coming. She's coming out of the breakout room now. Or at least I told her to come out of the breakout room back into the main lobby. I don't anticipate any other hesitancies.
Ms. Arcy, you need to unmute.
Yes, ma'am.
All right, did you understand we're back on the record. Did you understand by pleading true to violation of condition number 2, the court could find it true, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there an agreement? You're muted, Tom.
I'm sorry. Yes, Judge. Pending the court's approval, the parties are agreed to revoke and adjudicate the defendant. And we're going to ask that the court assess 190 days in the state jail, and that the defendant is going to have a surrender date. I'm not sure which Bill is going to ask for, but obviously since it's a motion to adjudicate, I think he has explained to her that she goes all the way up to 2 years in the state jail if she does not show up for her surrender date.
And that is the agreement, Your Honor. The only simple question here would be, someone uses whether or not she would be able to turn herself in directly to Dominguez.
No, she's going to turn herself into the 187 District Court. So the court is finding violation of condition number 2 true. When are you asking for her to present herself to the court?
Your Honor, we're asking for a period of 2 weeks for her to get her children and everyone situated.
Norma, can you recall this case for 2 weeks, please?
Yes, ma'am. Give me 1 second. April 15th, Judge.
All right, we'll see you here on April 15th at 9 a.m. You're to come to the 187 District Court. That's 300 De La Rosa, 4th floor, at 9 a.m. on April 15th. Do you understand?
Yes, Your Honor.
All right, we will see you then.
May we be excused, Your Honor?
Yes, thank you. All right, we are done for the day, everyone. We're going to stop the live stream. Hopefully everyone will have a safe Easter. And also